first, Paul Gigot and the Supreme Court's problem with liberals.
I'm glad that McGurn's handling the Romney problem.
I am too, Paul. But Bill will take on anything. Now let's talk. There's been a big backlash against these oral arguments that we had before the Supreme Court last week among liberals. They've gone ballistic pretty much. I'd like to read from a New York Times editorial, which I think kind of sums up their complaint.
A brave man.
Yeah. The Times says, if the conservatives decide that they can sidestep the Constitution to negate Congress's choices on crucial national policies, the court's legitimacy will pay a very high price. There's a lot going on in that sentence.
You wonder if that's, did they write that in 1803 when Marbury versus Madison came down? That's the case that established judicial review in the United States. And for the next 209 years, the court has been overturning legislation. So what does that mean? I mean, I guess it means that they think that in this case, there's such a patent lack of constitutional justification for overturning it that that would be illegitimate. Well, okay, make an argument for that.
Yeah.
The Solicitor General tried. The justices listened to him. A lot of briefs tried. You won't find the argument in the editorial, but you know we've looked at it and we think we just disagree on the Constitution. But I think what this is doing, Dan, this is a case of political pressure. They're trying to lobby the court. They're trying to lobby the refs, basically, work the refs, and say, wait a minute, you do this, Justice Kennedy. And notice a lot of the criticism of the court focuses on Scalia, focuses on Alito, focuses to some extent on Roberts, less on Kennedy, because I think they hope, well, we'll bring Kennedy over. But they're showing him at the same time, you join the majority, you make it a 5-4 majority to overturn even part of this law. Hell to pay, brother.
Well, you know, what's interesting, it's kind of paradoxical, is that they're accusing the Roberts Court of judicial activism, of overstepping its bounds. The suggestion is, the implication they're leaving is that, you know, this case does involve the Commerce Clause, that if they overrule some part of the Obama health care law, they will be dismissing some of Commerce Clause precedents. But that does not seem to be what's at stake here. Those Commerce Clause precedents are probably going to stand even if the court overturns a piece of this law.
I would assume so. The plaintiffs didn't even ask for them to overturn a single precedent. So stare decisis, which we're supposed to be so cognizant of on the court, which is, you know, the value of precedents, doesn't even come into play. Yet there are all kinds of cases. In the editorial we cite two, which is a case about gay rights, where they overturned a precedent, Lawrence v. Texas, from only 14 or 15 years earlier. And then another one on juvenile death penalty, where they overturned a precedent for, again, only a relatively recent precedent. In this case, it's really the court is being asked not to overturn precedents, but to determine whether this law, Obamacare, actually goes further than the Constitution allows as a congressional power in ordering individuals to behave in certain ways, to buy a product.
Yeah.
So, judicial activism, this is exactly, I think it's nonsense in this case. This is exactly the kind of case the court is always asked, routinely asked, to look into.
Well, you know, I think what's kind of interesting about this incident is that the Supreme Court case and its arguments can be a little mysterious to a lot of people, but this case got so much attention that those 3 days were a form of national education, I think, for the American people. They learned a lot beyond the substance and details of this case. For instance, the second day, I'm struck again in this argument here, the second day was devoted almost entirely to the issue of severability, whether you can overturn one part of the law and the rest of it stands. Now, the case the New York Times and these critics are making is though you cannot touch any part.
I think it was the third day was severability.
The severability in the third day. The idea is that you can't touch any part of this law without, touching the rest of it. But severability is just the most normal thing in court cases with legislation.
Well, the Supreme Court's precedents on severability are kind of a mess. There isn't any clear standard that they've established over time. But you're right, it does this all the time. It has to consider, as it looks at one element of a law, are they going to overturn the entire law? But notice in this case, the Solicitor General himself, arguing the administration's case, said if you overturn the individual mandate to buy a product, then at the very least you have to overturn the main regulations that the mandate is supposed to enforce.
Yeah,
so,
and finance.
And finance. So that is a crucial part of this. So they don't have to listen to the plaintiffs. They can listen to the Solicitor General if they overturn the mandate. I agree with you. It's been a fascinating education. And I think it's a shame that you see the political left, which dismissed this as preposterous only a week ago, is now saying, oh my God, the Supreme Court is really going to overturn a law?
Yeah.
I mean, they do it all the time, the Supreme Court does, and most of those times the liberals celebrate it.
Yeah.
They certainly did in the Bush administration.